Ready, start. In fact, the final surveyor's report is not conclusive with regard to the cause of fire, and there is no finding, leave alone any conclusion in the final surveyor's report that the insured caused the fire. Accordingly, this court is of the view that in the present case, the incident of fire is an accidental fire and is an occurrence which reasonably and otherwise is an occurrence within the terms and conditions of the insurance policies. Consequently, this court is of the opinion that the basis for rejecting the claim by the final surveyor and insurance company is contrary to record, untenable in law, and suffers from arbitrariness and perversity. Even otherwise, this court is of the opinion that the National Commission's view on this issue is well considered and cogent and does not call for any interference. The principles relating to interpretation of insurance policies are well settled and not in dispute. At the same time, the provisions of the policy must be read and interpreted in such a manner so as to give effect to the reasonable expectations of all the parties, including the insured and the beneficiaries. It is also well settled that coverage provisions should be interpreted broadly, and if there is any ambiguity, the same should be resolved in favor of the insured. On the other hand, the exclusion clauses must be read narrowly. The policy and its components must be read as a whole and given a meaning which furthers the expectations of the parties and also the business realities. According to us, the entire policy should be understood and examined in such a manner, and when that is done, the interpretation becomes a commercially sensible interpretation. Consequently, this court is of the view that the policies provide for coverage of single inverted comma FFF single inverted comma close, which can only mean furniture, fixtures, and fittings, and the insured is entitled to the amounts claimed under the heads of building, plant and machinery, showroom, electric fittings, furniture, and fixtures. In the facts and circumstances, this court finds that the purchase orders and emails regarding cancellation of orders contain the details of orders buyer wise, description wise, quantity wise, and value wise. Insofar as the quantity of the products damaged/destroyed in the fire are concerned, the closing balance figures of such items are reflected in stock movement detail and stock statement as on 24th September 2010 of the unit where the fire incident took place for the two floors, namely ground floor and first floor. The same was relied upon and shared with the surveyor. This court randomly tested the veracity of five figures given in the said list of cancelled orders against the backup/primary evidence/documents. No discrepancy was found except in one instance, namely serial number 32, wherein the quantity ordered figure is shown to be less than quantity cancelled. This was found on account of the fact that production of said product was more than what was ordered. This figure is corroborated by contemporaneous documents like production movement records and stock details at three locations.